Welcome to Trust Me. It's complicated. Decoding estate planning, probate, and trusts with attorney John Marshall.
Hello, and welcome to the Trust Me, It's Complicated podcast. I'm your host, John Marshall. My podcast is dedicated to helping you understand the world of trust estates and planning for the future. My goal is to make these topics less intimidating and more approachable. Whether you're creating your first estate plan, navigating probate, or trying to protect your family's legacy. Each episode, I'll break down the complex legal concepts into plain English, share practical insights from real cases, and give you the tools and knowledge you need to make informed decisions about your future and your loved ones. Estate planning isn't just about documents, it's about people, families, and peace of mind that comes from knowing you've planned ahead. So let's dive in and start building clarity, confidence, and security together. And tonight, we're going to talk about trust administration. I know that's a topic everyone has been dying to hear about, and I hope that pun is understood to be exactly that, just a pun. But anyway, we're going to talk about trust administration from two different aspects. One, what happens if you're alive and you're incapacitated? And two, what happens with trust administration after you die? So to first understand trust administration, you have to understand the purpose of a trust is to basically enable someone to manage your assets both during life and after death outside of the jurisdiction of the court. We really don't want the courts involved. If you are incapacitated and you don't have an estate plan that's properly put together, you could be subject to a guardianship. There's only one person who likes guardianships: the attorney. Why? Because of fees. It's an expensive process, it's a timely process, and nobody really enjoys it. Not even the attorney, but we do get paid well to handle it. But if I'm doing my job right, my job as an attorney is to help you not be put into a situation where that issue comes up and you need a guardianship. But we also look at trust administration from the standpoint of what happens after death. Okay, so again, distributing assets after death. But let's start with life. When you are incapacitated, you will expect that your successor trustee is going to step up and manage the assets that are in your trust. Okay, usually a good trust is matched with a good power of attorney. And the purpose of the combined power of attorney and the trust is that you can enable people to handle assets that are in your trust, meaning they're owned by your trust, as well as handle assets that are not yet owned by your trust or may not be controlled by your trust until a future date, such as IRAs. You can't put those in your trust while you're alive, but again, that's where the power of attorney comes in. We're not getting into powers of attorney on this episode. We will address that later. Nonetheless, while you're incapacitated, you have the successor trustee that can step in and manage your assets. Now, people oftentimes say, well, I picked my successor trustee, but what do they have to do? Well, first of all, a successor trustee has to understand what their duties are. And they are a fiduciary, meaning they can only do what is in the best interest of you while you're alive or the best interest of your trust beneficiaries after death. And what are these duties? Sometimes people say, well, yeah, I may be a fiduciary, but what does that mean? Well, actually, the fiduciary duties are found in the Florida Trust Code. And without getting down into the weeds, let me just kind of give you a general overview. There's the duty to administer the trust in good faith in accordance with the terms of the trust. There's a duty of loyalty, meaning that you're going to administer the trust solely for the benefit of the beneficiaries of the trust, which is you while you're alive and the beneficiaries you've chosen after death. The duty to act impartially. The trustee can't say, how does this benefit me over someone else? It's got to be, I'm doing this for the benefit of another party. Duty to administer the trust in a prudent manner, meaning you can't sit on it forever. I've got a case right now where the guy came to me and he said, look, I got to hire you. My brother's a trustee. I've been waiting 3 years for him to make a distribution from the trust. The brother, who's the trustee, has already breached the duty to administer the trust prudently because he's taking so long to administer the trust. There's also the duty to take reasonable steps to protect the trust assets. We have to make sure that the home is secure. Where are the assets? Who has control of the assets? What are we doing to make sure that those are not diminished, wasted, or stolen? There's the duty to account and maintain records. That's a big one where people will come to me and say, well, my brother or my sister's the trustee. And I ask for them, well, where are the bank records? I don't know. What have you spent? I don't know. Well, that's not good enough. That has to be accounted for. You must maintain records. There's also the duty to enforce claims, defend actions, preserve trust property. So if, there's a claim against the home because there was a hurricane and there was damage to the home, hey, trustee, you've got to pursue that claim to make sure that you protect the home. You've got to go after the insurance company and do what you need to do there, even if that means hiring a law firm to pursue that claim. There's also the duty to keep trust beneficiaries informed. You have to account. And we're going to talk more about that here in a minute. And there's also the duty to exercise a reasonable care and skill in administration. You can't just come in and go, well, I tried. Well, no, if you run into an issue, you need to exercise reasonable care and skill by saying, hey, if I can't do this, let me hire an attorney, let me hire an accountant, let me hire a financial advisor to assist in this performance of my duties. In other words, you can't just say, well, I didn't know, and therefore don't worry about it. No, you still have to act reasonably under the circumstances in getting assistance to make sure things are handled properly. Now, like I said, the duty that a trustee owes shifts. While you're alive, the duty is to you, meaning the trustee uses your assets to pay your bills. They protect your assets. Again, I'm going to bring up the home. If you're in a nursing home, but the home is still there and you still own the home, which under Florida can be quite beneficial, even if you're in a facility, you want to make sure, is the insurance being paid? Are the utilities being paid? Property tax being paid? What are you going to do to protect my assets? Again, resolve claims. Something that happens a lot of times is people say, yeah, my mom's in the hospital. And I just went through and I paid all of her credit cards. And the first thing that runs to my head is, did you ever call the credit cards and say, hey, mom is in the hospital. She's in a coma or she has dementia and I'm trying to get her affairs in order. Can I negotiate that bill down? That's something that you should do as a successor, or your successor trustee should do. The other thing is too, if you're incapacitated and your successor trustee steps up, they should also make sure that your assets are properly invested and maintained. If you want to do options trading with your money, that's your choice. But a successor trustee should not be options trading. If you have high risk investments, they shouldn't be, maintaining those. They should look at the market and say, hey, I need to act as a prudent investor in this circumstance, because there is a law called the Prudent Investor Rule that addresses that. And they should say, well, what can I do with these assets to preserve the assets to pay for what my incapacitated family member needs versus, well, how do I maximize returns? That's something that, again, as people get older, they need to think about shifting from maximizing returns to preserving capital. And we do expect successor trustees to do that. And that's something that a successor should be looking at if they take over while you're alive. This successor trustee has to account to you. Now, if you're competent and you say, hey, son, Johnny, you take over as trustee, you pay my bills, all that. All right, Johnny just accounts to you. But if you're incapacitated, Johnny has to account to your legal representative. And who might that be? Your agent under a power of attorney, and your healthcare directives, your surrogate under your healthcare surrogate form, or things like that. But what if the trustee fills both roles? They're your legal representative and your trustee. Well, in that case, the trustee has to account to the beneficiaries that would inherit after you die. And the purpose of that is accountability. One of the things that people oftentimes fail to remember in appointing a trustee is you need to appoint somebody who's trustworthy. I mean, that's right there in the word, trustworthy. But sometimes they go, well, I'm just going to name my son because he's the oldest, or my daughter because she's the oldest. Well, are they the best suited? And if they aren't, well, maybe they shouldn't be appointed. If they have a history of bankruptcy and stuff like that, maybe they shouldn't be appointed because they're not good money managers. But sometimes people come in and say, well, I want to appoint my son and my daughter as co-trustees. And I say, why? Well, my son's the oldest, but, I want to make sure that he does things right, so I'm going to appoint my daughter. Well, the son's already got to account. So it's not a matter of, accountability by having co-trustees. The accountability is baked into the law. There are certain duties a trustee has to do, and that is accountability. That's part of it. And failure to do that is a breach of their fiduciary duties, and they can be removed as trustee for that purpose. Now, it seems a little bit more straightforward while you're alive, because if we boil it down, it's pay my bills, protect my assets, and account to me. But after you die, things change quite dramatically. Because at this point in time now, you, the person who made the trust, has passed away. Now the trustee's duties shift to the beneficiaries. But there's also a duty to other people beyond your beneficiaries. For example, IRS. Yeah, we got to account to the IRS. In other words, what is that? File your taxes. We also have to look at any debt you have. Do we have to pay those debts? And this is something I tell my trustees all the time. Just because you get a bill in the mail doesn't mean pay it. Talk to us. Because sometimes you have to pay it, sometimes you don't. But even if you have to pay it, you can sometimes negotiate it down. And we can always assist with that. But just because you have a trust and are not going through probate doesn't mean there still isn't some things that have to be done with the court. Under the Florida Trust Code, a successor trustee must file with the court a notice of trust. And this notice of trust goes into the public record, and it says, hey, we're not doing probate. We have nothing to probate. But so-and-so has died, and we're now administering the trust. So if you have any claim against the trust, whether it's for a debt or things like that, contact me as the trustee. Okay? And that is required to go into the public record. We don't publish it. Doesn't go into the paper, but we have to file the appropriate pleadings with the court. I personally tack on an extra pleading called a caveat. And what a caveat says, if anybody tries to open my probate estate, the trustee or the personal representative who's nominated in the will must be notified. And the reason for that is you may have people that try to open up a probate estate looking for assets, trying to make a claim against them. And we want to put a stop to that, or at least have the right to file a competing petition for the appointment of a personal representative in a probate estate. We also have to submit the original will to the court. So even though we're not necessarily going through probate, the purpose of a trust is to avoid probate, we still have to submit the original will and a short form death certificate. In Florida, we have two death certificates, short form and long form. Long form has the cause of death, has a social security number on it. The short form does not have a cause of death, does not have the social security number on it. We use the short form for court filings and things like that. Long forms are typically used with insurance claims, health claims, and things like that. So we submit the notice of trust, the caveat, the original will. So a lot of trustees go, okay, I've done my duty. Now I'm going to start distributing assets. Nope, we're not there yet, because we need to do an initial inventory of the assets in the trust. Now, technically, an inventory and accounting is not due until 1 year after death. I personally, when I work with trustees, I'd like to do an inventory up front so we have a beginning number. We understand what the assets are. And so that kind of gives us the starting point for purposes of accounting, which is required under the trust code. We identify creditors. If there's a valid debt that we have to pay, can we negotiate it down? We also have to file taxes. And when we say file taxes, I'm not worried about estate tax for most people. We're talking about your final income tax return. So we have to address that. We also have to go through the process of collecting the assets. So your successor trustee steps in, you've passed away, and you've got bank accounts kind of spread all over. Well, the trustee now needs to go through the process of collecting those accounts and consolidating them into a smaller number of accounts. It doesn't mean liquidate everything to cash, but it may mean, hey, my cash assets that are all these different banks, I'm going to put them in one account at this bank, and maybe my stocks, my bonds, everything that are held with these multiple companies, I'm going to put into this one account, with this one particular company. But that again makes it easier to identify the assets and account for them. Now, in the process of that too, the trustee has to, as I mentioned earlier, make sure the assets are properly invested and maintained. They can't be doing risky stuff with it. I had a situation earlier this year where the trustee said, yeah, when the grantor of the trust died, the stock market tanked. And, because the election just happened and there was all this uncertainty. And so I'm just leaving it in there until the market comes back up. And my response is, but what if the market keeps going down? You're going to lose more money. You've got to cut your losses while you can, or at least move them into less risky ventures. Because this lady that passed away was actually in some very high risk stocks. And I said, you as a trustee, if you don't take actions to cut your losses, you could be in violation of the prudent investor rule. You could be in violation of your trustee duties, your fiduciary duties. And here's why this is important. If you were to be sued and the court were to find that you violated your fiduciary duties, you, trustee, can be held liable out of your own pocket. Or you can have your inheritance just reduced to cover the costs of losses to the other beneficiaries. And see, that's why being a trustee is sometimes a little bit more than people bargain for. They're not understanding the personal liability for it. We talk about addressing taxes. I've had situations where people come in and say, well, I distributed everything, and now the IRS says, I got to pay the tax. And I'm like, well, yeah, you were the fiduciary. You had a duty to make sure taxes were paid. So let's go back and demand money back from the other beneficiaries to cover the tax. But if they don't cover it, you're going to have to pay it, and then we're going to have to sue the beneficiaries to recover it. But the IRS doesn't wait. So again, being a trustee, there's a lot of risk there. So we want to take things slow, calm, and handle it appropriately under the trust code. And when we do get ready to do a distribution, we do an accounting. We just don't start doling out money. This isn't Monopoly. We do an accounting and we say, here are the assets at the beginning. Here's what came in. Here's what we spent. Here's where we are. And here's the plan of distribution. We send it to the beneficiaries and we wait. Now, statutorily, they have 6 months to file an objection to the trust account. And if they don't, then you can make distribution. In my practice, we will send all the beneficiaries a consent form that says, I consent to the accounting, I waive objections, I consent to the distribution. And if all beneficiaries return that, then we'll make the distribution that's shown in the document. And the interesting thing is I have some people who say, well, another attorney told me I have to wait until everything is wrapped up before I can make a distribution. That's not necessarily the case. We can do a partial distribution, maybe distribute 80 to 90% of the trust assets. But we hold back enough to get us through tax season to make sure we wrap up things accordingly, okay? And then in money left over, then we distribute that money. So, again, we want to make sure that we do things appropriately. In this, 20-minute podcast, can I give you a full breakdown of everything that goes into a trust administration while you're alive and after death? No. But the purpose of this is to give you an idea that there are rules. There are regulations. Your trustee has to follow these. And if your trustee doesn't, they can be held personally liable. That's where attorneys like myself at Marshall Law come into play. Our job is not only to set it up properly, but to assist trustees in the performance of their duties so that your intentions with regard to your trust are fulfilled, they are properly doing their job, and are protected from claims of the other beneficiaries. And at the end of the day, everyone gets exactly what you intended them to have without any legal hiccups or problems. So if you want to talk further about this, give us a call at Marshall Law. We can help set up your estate plan. We can set the foundation. If you are a trustee and you want to know how do I do this properly, call us. We can represent you in the performance of your duties as trustee. At the end of the day, we're here to help you through this entire process. I'm John Marshall. Thank you for listening. We look forward to having you listen at a future podcast where we're going to talk about more trust and estate related topics and content. Thank you and have a good day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.